My name is Alma Pinkham and I will be the facilitator today. I am working in the Corporate Education Unit of CIPC. We hope that you will find today's presentation interesting and that each of our participants gain new knowledge about the subject matter. Before we have a look at today's program, I just want to welcome you again, and I also want to give you some information regarding the webinar, as well as a few house rules that we request you comply to. Today's webinar will be recorded, and as soon as the recording is available, it will be emailed to every person that registered for the webinar. We have a short survey that we'll do after the presentations, and then there will be a question and answer session. You are welcome in the meanwhile to post your questions on the chat function during the presentations. If we do not get to your question during the presentations or during the question and answer session, we will follow up afterwards. The most important bit of house rules today is please switch off your microphone at all times in order to prevent background noises during the webinar. Should you ask a question during the question and answer session, then you can unmute yourself for the time you're speaking. Lastly, also switch off your camera, please. We find that if cameras are on, it draws people's attention away from the presentations, and we would like everybody to focus on the presentations. If we can then move on and look at our program. I'm busy with the welcoming. We're going to do a short introduction to CIPC, and then I'm going to hand over to Lucinda Steenkamp, who's a senior legal advisor in the corporate legal unit. She will be doing our presentation on MOI amendments and company shares. Thereafter, I will hand over to Mojalefa Khoza, who's a senior education specialist in the copyright unit. His subject will be strategic management of intellectual property. And then we'll do a very short survey. In case you do not get it right to do the survey, we will also email this to everyone after the webinar. And we kindly request that you complete it in that instance, and once you've submitted it, it will come through to us. Your feedback is very important to us, so please complete it either during the session or afterwards. Then we're going to get to the question and answer session, where you will be allowed to ask your questions. I ask that at that time you put your hands up. There is a hand that you can put up on this MS Teams. Is such a function, you can do that, and then we will take turns allowing people to ask their questions, and then I'll be closing our program. We will start with a very short introduction to Companies and Intellectual Property Commission, the CIPC. CIPC was brought into existence by the Companies Act of 2008. In terms of Section 1851 of the Companies Act, the Commission is established as a juristic person to function as an organ of state within the public administration, but as an institution outside of a public service. CIPC is an agency operating under the DTIC, that is the Department of Trade, Industry and Competition. If we look at the structure of CIPC, broadly, one can say it has two legs. On the one side, you have the businesses, the corporate regulation sections, which include companies, CCs, and cooperatives. And then on the other hand, you've got the intellectual property, innovation, and creativity units, which the domains are patents, designs, trademarks, and copyright. We can look at the CIPC mandate. This mandate is also coming from the Companies Act in Section 186. Our objectives there include registration of companies, cooperatives and intellectual property rights and the maintenance thereof, disclosure of information on our registers, enforcement of the relevant legislation, promotion of education and awareness of company and intellectual property law, licensing of business rescue practitioners, monitoring compliance with and contravention of financial reporting standards, and making recommendations thereto. We also report, research and advise the Minister on matters of policy on the company's and intellectual property law. And then CIPC provides offerings to enable sustainable businesses. To just give a quick look at this, we reduced administrative burden in the corporate law reform and IP law amendment. We maintain a reputable business and IP environment for South Africa. We have a 24/7 CIPC services and minimize time spent transacting with CIPC. We do compliance, monitoring and enforcement of the acts. There's increased collaboration with partners. We also have increased our access channels. These channels include the SSCs, the self-service centers, as well as partner sites where they have self-service terminals. There's e-services website, the BIS portal, mobile app, USSD, social media, call center and banks. We have simplified the annual return annual returns and financial statements filing through automation. We focused education and awareness programs. IP has been relatively unknown with disadvantaged communities in South Africa. It is therefore important to make people aware of IP and to encourage them to acquire knowledge in this area. We have things like the trademarks accession to Madrid, which is cost-effective international filings. There's reduced new application and renewal fees available to SMMEs when the IP fees adjustments take place. There's patents, which have an inventor assistance program on our website. There's an IP trade portal. There's technology and innovation support centers and an IP SMME toolkit. With that said, I'm going to hand over to Lucinda Steenkamp. I may just add that we will also be emailing you the different presentations of today. Thank you, Lucinda.
Thanks very much, Alma. Just a quick sound check. Can everybody hear me? If you just, okay, I get a few thumbs up here in the office. That's great. I'm just going to turn on my camera quickly so that those of you who don't know me can see what I look like while I'm speaking to you. But while during the presentation, my camera will be off. Thanks for everybody confirming that the sound is fine. Okay, without any further ado, Alma, I see there was a question about whether we're recording. Are we going to start only now or we're recording already? Okay, great. Let me just get this presentation shared. Okay, can everybody see the presentation? Is it visible? It's slow, just give it a few seconds. Okay, here we go. I'm just going to talk to you today about MOIs in general and the amendments that can be done in accordance with your MOI as well as the company shares. Just a short introduction with regards to MOIs. This is a very important document that any company needs to have. This is your governance document, and how you trade, etc., is incorporated in this document. For different types of companies, you have different types of MOIs, and the content differs based on the company type and how a company wants to be ran. Every single entity can have its individual MOI and enter anything into that MOI as long as it's not in conflict with the Companies Act. So the content for today is just going to be your MOI of Memorandum of Incorporation, or MOI, your amendments to the MOI, which ones are registered with the CIPC and why, capitalization of profit companies, that's sections 35 to 38 of the Companies Act, and the conversion of shares and regulation 31 of the Companies Act regulations. The conversion is separate because it's very important how to do the regulation or the conversion of the shares. And lastly, your transitional arrangements that's contained in Schedule 5, items 4 and 6 of the Companies Act. Is everybody fine with sound? All right. Your Memorandum of Incorporation is defined in the Companies Act 71 of 2008 as the document that sets out the rights, duties and responsibilities of your shareholders, directors and any others within and in relation to your company. This is your corporate governance document and dictates any other matter as contemplated in section 15 and by which the company was incorporated under this act as contemplated in section 13. So your Memorandum of Incorporation regulates your corporate governance in terms of any entity registered in terms of this act, as well as a pre-existing company that was structured and governed before the 1st of May 2011, which was the effective date of the current Companies Act, or the date it was converted to a company in terms of Schedule 2. This is where we are talking about your closed corporations or cooperatives that was converted to a company after the 1st of May 2011, or a domesticated company is structured and governed in terms of Section 13, as I already said. The following constitutes amendments to the MOI, and these must be filed with the CIPC to ensure up-to-date data on our records. Adoption of a whole new MOI, the amendments of certain sections of the MOI, for example, the removal of audit requirements in private companies. In terms of the old Companies Act, it was a requirement to have private companies audited, which was removed in terms of the new Act, and companies have to effectively remove that audit requirement from their MOI to ensure that they don't have to have an audit. Name change of a company is an MOI amendment because it's a change to your governance document. The main business amendment, this is not required in terms of profit companies, in terms of the new Act, but may be filed. So you can still file an MOI amendment and request your company to have a main business indicated. NPCs, very important, must have a main business indicated. This is detailed in Schedule 1, Item 1 of the Act. Any authorized share amendments, increase, decrease, creation of shares, conversion or reclassification qualifies as an MOI amendment. The company type change, NPC, non-profit company, may not convert to a profit company. However, a profit company can convert to a non-profit, and other type changes are allowed, for example, from a private company to a public. Ring fencing of the MOI, Section 15.2 of the Act, which imposes a higher standard, a greater restriction, or similar onerous requirement on that specific individual company. An example of ring fencing is where directors are only allowed to contract with a third party on behalf of the company to the monetary value of 300,000. That is a specific additional restriction that is placed on that company in itself, and it needs to be indicated as a ring fencing condition. Should a third party therefore contract with a director over the amount of 300,000, then they cannot claim that they did not know this, and it may invalidate that contract because the ring fencing conditions was indicated in the MOI, and any third party or investor, etc., is obligated to go through an entity's MOI to make sure that they understand the rules and rights, etc., attached to it. Everybody still with me so far? Right. Alterations of the MOI in terms of Section 17.1 of the Act. At any time, a correction of a patent error may be filed by an authorized person in terms of the Core 15.3 form. This is if there are grammatical errors, etc., within an MOI, then that can be corrected. Translations of the MOI in terms of section 17.3 may be filed with the CIPC for record purposes in any of the official South African languages and submitted under a COR 15.4. Just to note that the Afrikaans version of an MOI is seen as a translation and must be filed under cover of a COR 15.4. Afrikaans MOIs may be rejected because it is seen as a translation and not the normal language for these governance documents to be submitted in. Consolidations of the MOI. Section 17.5, at any time after a company has filed its MOI and subsequently filed one or more alterations or amendments, the company may file a consolidated version of it under cover of a COR 15.5, or the CIPC may require a company to file a consolidated version, and they will send you a COR 15.6 to request the filing of a consolidated MOI. The reason for this is that the latest version of a company's memorandum of incorporation that has been endorsed by the CIPC prevails in the case of any conflict between it, that MOI, and any other purported version of the MOI of a company. The authenticity thereof is based on the CIPC endorsement. Moving to capitalization of profit companies. Several sections of the Companies Act is devoted to company shares, registers, shareholders, etc. With the inception... Okay, everybody, I am back. Can you hear me?
Yes.
Now we can hear you.
We can hear you now.
We can hear you.
I'm going to just not use the microphone because it seems to be muting me without me touching anything.
Okay.
Okay, I'm going to start again with capitalization of profit companies.
Thank you.
Several sections of the Companies Act is devoted to company shares, registers, shareholders, etc. With the inception of the new Act in 2011, certain areas of shares, such as the issue thereof, premium accounts, share buybacks, don't move. Someone is moving the presentation. Is not relevant to the CIPC any longer. Share buybacks and the issue of shares, premium accounts, is not applicable to the CIPC any longer and requires no filing or registration thereof with the CIPC. However, companies should be cognizant of the fact that even though filing with the CIPC is not necessary, the Act may still require the proper passing of special resolutions, etc. So even though you don't have to file the issue of shares with the CIPC, companies still need to ensure that the proper special resolutions are passed and that they keep internal records thereof. Okay. Herewith, a few facts as determined by the Companies Act surrounding shares that you should be aware of. A share issued by a company is movable property, Section 35(1), and can be attached by a court of law, transferred, etc. Important to note, however, is that the CIPC is not the holders of these rights attached to shares, and no warrant of execution or attachment in terms of company shares and members' interests for that matter can be served on and or executed by the CIPC. So if you went to court with regards to a person that owes you money and you have a court order for attachment of his shareholding or members' interest, you cannot serve that warrant on CIPC. We're not the holders of that shareholding and we cannot attach that shares or members' interest. Companies Act 2008 removed the differentiation between shares with a par value or with no par value. Therefore, as from the 1st of May 2011, only authorized shares with no par value can be created. Section 35(2) of the Act. A company may not issue shares to itself. Section 35(3). An authorized share of a company has no rights attached to it until it has been issued. Section 35(4) of the Act. This does not mean that the MOI cannot contain the rights and privileges associated with the authorized shares of the company. It only means that these rights and privileges, as indicated in the MOI, will only be attached to the individual share once it is issued. That is very important to make sure that when you are dealing with the governance documents of a company, the rights, etc., attached to a specific share class can be clearly indicated in your MOI, but the rights are only attached once those shares are issued. CIPC Online e-Services platform provides for an automated share amendment service. Shares can be created, amended in terms of the Companies Act requirements electronically. The online service does not provide for the lodgement of an MOI to confirm the share amendment, which a lot of third parties raised a concern about. However, as discussed earlier in the webinar, shares may be amended without adopting or lodging a whole new MOI, and thus companies may proceed to tend to several amendments, shares, name changes, etc., and only then lodge a consolidated MOI that combines and confirms all the changes made. A company's MOI must set out the different classes of shares and the number of shares for each class. And the MOI must set out, section 36(1), a distinguishing designation for each class of shares and the preferences, rights, limitations, etc. attached to each class. To give you an example of what we mean with a distinguishing designation, a company cannot have the same class of shares with different values. For example, 1,000 ordinary par value shares of R1 each and 1,000 ordinary no par value shares. Your 1,000 represents the number of shares, ordinary represents the class, par or no par is the baseline value, and then R1 or none is the rand value attached to the share. Now, the above represents the exact same class of shares, ordinary, with no distinguishing factor, with different values, which cannot be allowed. In order to ensure compliance with the Companies Act, section 36, a company must add a distinguishing designation to each of its classes to allow for the CIPC, shareholders and potential investors to be able to differentiate between the different classes of shares and the rights, etc., attached thereto. An example, 1,000 ordinary par value shares of R1 each, or 1,000 ordinary Class A no par value shares. So although both classes are ordinary, the above designation Class A distinguishes the ordinary class with no par value shares from the ordinary class that has existing par value shares. A lot of authorized share applications are rejected due to the use of the word common to describe a class of ordinary shares. There is no such thing as common shares, and it is not reflected in the Companies Act anywhere. Reference to common shares was made on the standard COR 15.1A and COR 15.1B forms, which was an error by the legislature and was corrected in 2012, notices of which was published in the Government Gazette. A company may, by special resolution, authorize the alteration of its share capital in one of the following ways. Increase its share capital by authorizing new classes of shares or increase existing no par value shares. Decrease or cancel classes of shares. Subdivide its shares or part of them into shares of smaller amounts than is fixed by the MOI, in essence an increase in shares. Convert all of its ordinary or preference share capital consisting of shares having a par value into stated capital constituted by shares of no par value. Cancel any unissued shares of par value and reduce the authorized share capital by the amount of the shares cancelled. Convert any of its shares, whether issued or not, into shares of another class, which we call the reclassification. A company's MOI may also provide for unclassified shares. Please note that the Act says unclassified. It is not blank or any other word, it's unclassified shares. Shares where the associated preferences, rights, and limitations of that class of share have not been specified or indicated. Conversion of shares and Regulation 31 of the Companies Act regulations. The Companies Act provides for pre-existing companies to retain its par value share classes. However, no new classes of par value shares may be created except for banks. That's the only exception. A pre-existing company may, in terms of Regulation 31(3)(b), convert that class or classes of authorized shares having a nominal or par value to shares having no nominal or par value. Regulation 31(7) authorizes the board of the company to effect a conversion at any time by an amendment of the company's MOI on condition that the amendment must be done primarily to must not, I just said, yeah, don't say must be done, must not be done to evade tax legislation, the capital gains tax, and be approved by special resolution of the holders of the particular class of shares, as well as the company's shareholders. Just basically what this means is that you can convert your existing class of par value shares to no par value, but very important is the fact that this must not be done purely for evading tax. The board must present a detailed report on the nature and effect of the amendment, the reasons why they are amending and what the effect thereof is going to be. This report must be circulated to the shareholders prior to the meeting, and a copy thereof must also be submitted to SARS. How that is submitted, we cannot tell you, as long as you have proof that it was submitted to SARS and they throw it in the bin, that's not your problem. Although the Act provides for independent submission of the report with the CIPC, practically CIPC requires the report to be filed with the application to convert and not separately. This is for record purposes. The transitional arrangements in terms of Schedule 5, with the incorporation of the Companies Act, transitional arrangements were necessary to ease existing companies into the legislative changes. Two items of Schedule 5 is relevant and applicable to our discussion on MOIs and shares. Item number 4 of Schedule 5. Every pre-existing company is deemed to have amended its MOI to reflect that it is a private, personal liability, public, or non-profit company in accordance with the Companies Act of 2008. Limited by guarantee companies were done away with in terms of the new act and were given 20 business days to become a profit company. So you had to file the conversion from one company type to another under cover of the COR 15.2. All companies that did not elect to do so were automatically converted to non-profit companies by the CIPC. Legislatively, companies were given 2 years to adopt and file with the CIPC updated MOIs in substitution of its memo and articles to bring it in line with the current Companies Act. Companies that did not do so, and there exists a conflict between their memos and articles and this act, the act prevails. That was the one that I mentioned earlier with regards to the removal of the audit requirement, for example. Item 6 of Schedule 5, par value of shares, treasury shares, capital accounts, and share certificates. The creation of new or increase of existing classes of par value shares does not apply to banks as defined in the Banks Act, and thus only banks may create new classes of par value shares. So companies are allowed to hold on to their existing par value shares, but they cannot create new par value shares or increase the existing number, except for banks. If you are defined as a bank in terms of the Banks Act, you can create par valued shares until such time that the minister says otherwise in the Government Gazette. Holders of par value shares, pre-existing companies were and are allowed to retain such par value shares, as I've mentioned, with the exact same rights and preferences attached as per the previous Companies Act. Companies should have amended its share certificates, but a failure of any share certificate to satisfy the requirements of sections 51, subsection 1 to 4, the content of the certificate is not a contravention of the Act and does not invalidate that certificate. CIPC holds no record of shareholders or shareholding information, and share certificates must be dealt with by companies internally. CIPC cannot issue you with a share certificate. That being said, well, it's not time for questions yet, but that is the end of my presentation. Sorry for the technical issues. I will deal with all of your questions as soon as Elma gives us the go-ahead. Thank you.
Thank you.
Thank you, Lucinda. Now we're also going to give Mojilefa Koza an opportunity to do a presentation on strategic management of intellectual property. Mojilefa, can you share your presentation with us?
Thank you, Elma. Let me try to do exactly that. Can you see my presentation, everybody?
No, but it is a bit
yet.
slow. Let's just give it a few seconds.
Okay.
He's just putting his camera on. He just wants you to see him.
It shows on my screen. Can you see it from that side?
Not yet.
Not yet at the moment.
I've shared it. Let me try to share it again. Okay, I can see it now.
Can you see it?
Yes.
Okay.
Yes, all right. Just leave it on that slide for now.
Okay, I think more people are seeing it now. I think you can start. We will, in any case, send the slides to everybody after the webinar.
Okay. Thank you, everybody. Good morning. My name is Mojilefa Koza. I've switched my camera on so that you can see who you're speaking to. When we got an invitation to come and talk, we looked at what the topic for the day was, and it was on the MOI and the amendments that goes with it. And we thought we could share with you a few slides on how you can use the Memorandum of Incorporation to manage your IP if you are a company that has a portfolio of IP. And even if you are a new company, and you want to file a Memorandum of Incorporation, you can consider including in your Memorandum of Incorporation intellectual property and how you're going to manage it. Just like Lucinda has said, shares are movable properties within a company, and as a result, they become a very important component of any MOI, whether the company is an established company or whether the company is new. Now, we thought we can share with you information on how, besides a company policy, you can actually strategically manage your intellectual property by including it and entrenching it in the MOI. We looked at different companies and we realized that there are companies who operate within the creative space, big companies who are very innovative, who are from day-to-day basis or monthly basis, they come up with intellectual property, be it patents, be it copyright, be it designs, be it trademarks, and be it trade secret. There are companies who've got a vast portfolio of this kind of IPs that I am talking about. However, we have come to realize that most companies, some of them even big, some of them even small, do not even have a policy as far as intellectual property is concerned. So I'm here just to share with you that you can use an MOI as one of the methods that you want to use to strategically manage your intellectual properties. Because we know that big companies who operate within the creative and the innovative space, they possess a whole of individual creativity and skill and talent. And during the course of their operation, they generate a whole lot of intellectual property that needs to be exploited. The intellectual property belonging to the company may be strategically managed in an MOI. Just Lucinda has said, you can HOI anything that you want in the Memorandum of Incorporation as long as it's not in contravention with the Companies Act. So we thought, why not also considering HOIing in intellectual property in your Memorandum of Incorporation? And I'll tell you why. Because it's pretty important. The MOI may pronounce high IP might be produced by employees, for example. We've had several cases in companies where an employee during the course of his employment would come out with IP. Now, the question would be, would the employee be allowed to own the IP, or when the employee leaves the company, will he be allowed to share the intellectual property that he has created while he was in the employment of a company? So those are the things that you might consider putting into your memorandum of incorporation and entrench them and make sure that they don't become a problem in future in case an employee leaves. I know for a fact that most of the academic institutions have policies as far as the ownership of intellectual property is concerned. For example, the law states it categorically clear, especially with regard to patents, that while you are in the employment of a company and during the course of your employment you come out with IP, the company retains the ownership of IP. However, there's a landmark case that everybody knows that made us realize that we should share this information with you. I'm sure everybody is quite aware of the case that happened between Nkosana Makate and Vodacom case. In this case, where this young guy, we were told in the newspaper, was actually the innovator and the creator of the please call me innovation or invention, if you like. However, we only to got to know about it in the news that there was a tussle between Nkosana and Vodacom, which ended in court. This is the case that actually opened our eyes to say, if you are a company, big or small, make sure that if you don't have an IP policy in place, make sure that you can use a memorandum of incorporation. Come again? Yes, can you hear me? Make sure that you can use an MOI to incorporate IP issues. For example, at the end of the day, we hear that the ruling was in favor of Nkosana Makate versus Vodacom. Now, so these are the cases that teaches us that we should always be aware and we should always strategically try to manage our intellectual property. Now, the MOI is such one platform or is such one document that can be used to strategically manage intellectual property. In other words, if you like, you can talk about the MOI and you can talk about IP in your MOI and spell out exactly how your intellectual property must be managed. For example, if an employee leaves the company, what is the policy or what is it that you want to contain in an MOI that makes sure that the company intellectual property is protected? For example, you can put a restraining order in your MOI to say, if you are an employee and if you were to leave us within the next month or so, for the next coming 3 years, you are not allowed, for example, to join any competing company because you are aware of this. You are aware of this intellectual property. You can even spell out how you want to exploit your intellectual property in your MOI. For example, issues of licensing can be clearly spelled out if you are a company that possesses a large portfolio of IP. You can spell out how you want to license the intellectual property, and you can even spell out how you want to handle issues of you as a company licensing in intellectual property from other companies. So these are the few things that we wanted to share with you so that you may ponder over them and consider including them in your intellectual property. So in a nutshell, this is just a few slides that we wanted to share with you to make you aware that you can spell out how you want to manage intellectual property in your MOI. This is how it can all start. This is the
Sound is gone.
Is on mute. You must check his mic.
Yes, I have unmuted now. We've used an example of a creative.
Yes, we can hear you.
Yes. If you look at the slide now, we've used an example of a company that operates within the creative space. during the course of their operation, it's quite obvious that these people will produce a lot of copyright. Now, when they produce copyright, it becomes IP. I'm using here an example of a company that operates within a creative enterprise space. Other companies might be operating in construction, might be operating in other sectors. They might come up with not copyright, but patents. They might come up with designs and even trade secret. Now, if you look at the third column, you must now, once you have produced IP, you must now come up with a strategy to make sure that the IP is well managed. I've given an example. You can license it out, and you can spell it out in the memorandum of incorporation. You can even spell out in the memorandum of incorporation how you're going to deal with commission work, and it must be very, very clear. And you must also look at the IP that was generated during the employment, whether the company owns it, whether the employee can use it when he leaves the employment of the company. It must be spelled out clearly in the memorandum of incorporation. Like I said, you must also include issues of assignment. If you decide to sell your IP, how are you going to handle it? How are you going to restrain employees that leaves a company to go to competing companies? There must be clauses that are well spelled out. In a nutshell, what we're trying to say to you, strategy that a company employs, you might also use the MOI to make sure that you manage your IP strategically as far as the issues of ownership are concerned. I think I should leave it right there now. Thank you very much for the 5 minutes allocated to me. Thank you, Elma.
Thank you, Mochalefa. May start. I think there's Zoli. I think we can give you the first opportunity. I think your hand has been up very long. I just want to ask that you unmute yourself to ask your question, and then after asking that you just remute it again, but we don't have any background noises, and then we'll answer your question. Zolani, your hand is raised. If you don't want to ask a question, you can just click again on the hand to lower your hand. Otherwise, yes. Now I see your sound is on, I think, or have you not disappeared? You were there second enough. Okay, let's ask for the next person. Sibusiso, I think you're next on our list. If you can just unmute yourself and ask the question you wanted to ask, please.
Good day, and thank you very much. My question, I think with regards to the CIPC, the number of shares, I remember when I was doing my company registration, I selected 1,000 shares. So I want to know, how do you split the shares if you want to sell them? Maybe like for other people who might be interested in investing in your company. So how do you go about in terms of saying, okay, do I sell within this 1,000 shares, or I'm just estimating that I've got 100, then I can determine the price of shares depending on the company value. So I want to know, how do we split the shares and also remain the majority shareholder within the company? Thank you.
Lucinda?
Thank you. To answer your question, CIPC is not involved with regards to the issue of shares as indicated. So we cannot provide you with legal advice on how to go about doing the issue of those shares or to sell those shares. You have to deal with that internally. It is a very intricate process to allocate shareholding and who is the majority shareholder, etc. So my advice would be to get help with that, whether through an attorney or you get specified persons that deal with these shares and list them on the JSE, etc., to assist with that.
Okay, no, thank you very much.
You're welcome.
The next person on our list, no sound on. Okay, is Mabinang. Mabinang, you seem to be disappearing, but you had your hand up. If you wanted to ask a question, you can just unmute
Yes.
yourself and ask the question, please.
Good morning.
Morning.
Can you hear me?
We can hear you clearly.
Okay, thank you. I have two questions. I registered my company last week and I selected the standard MOI. And now I realize that I have intellectual property. What is the procedure to amend the memorandum of incorporation? That's the first question. Then my second question is, what is the procedure to protect my intellectual property? Thank you.
Okay, so I can tend to your first question on if you want to include your intellectual property in your corporate governance documents, in your MOI, then you can merely adopt a whole new MOI by amending whatever paragraph is applicable to that. It's not going to be ring fencing. It's not going to be any particular section of your standard MOI. It's something that you're adding additionally. But CIPC won't register the special resolution to amend the MOI if you lodge the amendment only, because it's not one of those, as I've listed, that 7 that the CIPC needs to register or endorse for it to be applicable. So you will have to insert it into your MOI and then lodge it for adoption of a whole new MOI to make sure that it is applicable. I'm sure Mojilefa will answer your other question about protecting your IP.
Thank you, Lucinda. You have said that when you were registering your company, you started with a standard MOI. And what is it that you can do to make sure that your IP is included in the MOI? I think Lucinda has already answered. You'll have to move from a standard MOI to an MOI that you can actually include your IP. Now, as far as protection is concerned, my advice is before you even consider including your intellectual property in your MOI, make sure that it's protected. Now, the next question is, how do you protect it? Just like you register your company, we have a web-based intellectual property application system. All you do, go to our website, go to our IP services. Now that you're already a registered customer with CIPC, you have your password, you have your customer code. All you have to do is go to IP services, check out the type of IP you have. Is it copyright? Is it a patent? Is it a trademark, or is it a design? Once you've identified what type of IP is, for example, if it's a design, then obviously you click on design. Obviously you'd look at the fees, just like you would normally do with your company. You will deposit the registration fees, then you'll follow the steps that are there on our website. Each and every type of IP has a clear step-by-step guidance of how to register it. All you have to do is just follow it and complete the process. Then we will do the processing. After doing the processing, when it is accepted, obviously you'll get notification that your IP is protected. But one thing to note is that before you include it into an MOI, make sure that that intellectual property is protected. Simply make an application with us. Thank you. I hope I've answered your question.
Thank you very much.
Thank you, Mojilefa. You as the IP or part of the IP education unit, you're also doing some webinars. So I'm sure if people keep their eye on our website and our social media, they will see when there's invites and they will be able to learn a lot more about the IP subjects. If I can then ask Buti, he's next on our list. His hand is raised. Will you please unmute yourself and ask your question? Thank you.
Great, thank you. I have one question for Lucinda. It's a yes or no question. It's regarding the share clause. I just wanted to ask if, because you mentioned that a company cannot issue shares to itself. I just wanted to understand if she means that a company cannot issue shares, company A cannot issue shares for company A, or company A cannot issue shares for company B. I just wanted to understand right there. Thank you.
I'm trying. There we go. Yes or no question you said. So my answer is yes. You are correct. Company A cannot issue shares to company A. You cannot be a shareholder of your own company. So, but company A can issue shares. It muted itself. Okay, here we go.
Right.
Did you hear the answer? Yes, no? Okay, I'm just going to repeat quickly. Company A cannot issue shares to company A. Company A can issue shares to company B. So company B can be a shareholder of company A, if that answers your question. Thank you.
Okay, thanks. Next, I want to ask Marissa. She has her hand up. If she can unmute herself and ask her question, please.
Good morning. Sorry, thank you for taking my question. It might be slightly off topic. I heard a rumor that we're going to have to, in future, submit our share registers whilst we do our annual returns. Is there truth in that? And if so, the format of the share register, is there going to be a format that you're going to prescribe? Thank you.
Okay, sound on. Can you hear me? The species unmute themselves. They don't want us to talk. When there was advertising of the required amendments to the Companies Act, I think that was late in 2018 already. It was published for comments. That is part of, by the DTI, now the DTIC, there is part of it to lodge the share register when filing your audited financial statements and your annual returns. This is in the works, so to speak, but it hasn't been promulgated yet by the presidency. But we haven't developed any format or anything yet on what that is supposed to look like. But companies are urged to, because they have to keep a share register already with specific information contained in it. And so they will only now be required to file that with their financial statements and annual returns when it comes into action.
Thank you, I understand, but some people still keep it in that red book. Are you going to accept scanned copies? Sorry, thank you.
That's not a question that I can answer as yet. We will, when it comes into operation, when and if, then we will work on what it should look like. Most probably it will be in electronic data, much like the XBRL. So the process for submitting that will be detailed at that point.
Okay, yeah. Thank you. Yes, thank you.
Yeah.
Okay, next is Jordette. If you can unmute yourself, please, and ask your question. Thank you.
Hi, morning. I've lodged a manual company formation because the company is classified as ring fencing. I did the application on the 30th of August. I just want to know, is that still in the turnaround time, or can I imagine that this application has been lost and that I should resubmit? I have lodged a query, but I haven't received a response yet.
Unfortunately, Georgette, I can't answer a question about new company registration. I have no idea at what date they are processing, but I think you will be able to track your transaction via the CIPC website. If it has been tracked already, it will be reflected there on your customer code. If not, then it's safe to say that you can relodge.
Okay, yeah, no, it's not being tracked yet. So.
And you lodged it via company docs?
Yes.
And there is a customer code indicated with sufficient funds in it?
Correct.
Okay, then it may be prudent just to relodge to make sure that they receive it.
Okay, thank you.
Yeah.
Thank you. The next person is Candice. You can unmute yourself and ask your question.
Hello, good morning. I'm in a situation where my business was registered in 2017, and recently one of the directors, we were in a partnership and he's resigned. So I'm now the sole director. And this is where I learned now, I just updated my company registration. And then that's when I noticed that, the MOI is not updated. So from everything I've learned, I'll have to draft my own and resubmit that. But now also there's the notice of incorporation 14.1. From CIPC perspective, how do you go about updating that, or what is the process to update that?
Okay, Candice, so directed changes is not an MOI amendment. This is a process that you have to do separately via the Core 39 document, which you can also file online with supporting documents regarding the resignation, etc. So your MOI information will still be containing the minimum of how many ever directors you indicated, but it's not an MOI amendment, so there's no need for adoption or updating of your MOI. It's merely directed changes, which CIPC will incorporate. Once you lodge
Okay. I've already completed the Core 39 process, so that's done. But I noticed that the notice of incorporation is still indicating his name on there. So my question is, how do I change the notice of incorporation?
Remember, you can't change that. That is your historical documentation of your company incorporation. Your new certificate, after you did the Core 39, will reflect only the person that is now an active director. But the company history will still reflect what the directors were at incorporation and the changes that happened thereafter. So you can't remove that information. It's historical data.
Okay, thank you.
All right, no problem.
Okay, next is Boitumelo. You can unmute and ask your question.
Thank you very much again. It's for Mujalifa. The time he was explaining the IP protection and the company registration, the mic went off on my side, or my ear stuff went off. I want to ask the question again. Actually, I want him to repeat the part where he says whether a person register a trademark first before they register the company, or whether they should register a company and then do the trademark. Which comes first?
There
it's quiet again.
Yeah. Okay. Thank you for the question, Boitumelo. In most cases, people would register a company first.
Yes.
And when a company has been registered and the name has been approved and the company is up and running, people would come to CIPC and take the name of the company and register it as a trademark. My advice is register a company, after which you can register a trademark in the name of your company. If your company also have products, you can decide to trademark the name of your company as well as the products that your company has. I hope I answered your question.
No, it's okay. So I can register first the company, and the trademarks and the whatever IP stuff can then be registered after the company has been approved.
Exactly.
Registration. Thank you very much.
At the moment, I don't see any hands, but I want to ask Lucinda, there was a question I saw that came through on. There we go. At the moment, there's no hands, but I want to ask Lucinda, I saw there was a question that came through on the chat, where the question was whether MPC can have shares in a PTY.
I just answered it.
Okay. Lucinda says she just answers it, and the answer is yes. I want to ask, is there anybody else who have a question? Because at the moment I don't. Sorry, I don't know why this computer really mutes itself. I want to ask, at the moment there's no raised hands. Is there anybody else who want to ask a question?
They can ask on the chat or send me.
Okay, you can ask a question on the chat. Lucinda will respond. Or if, no, I see there's hands again, but I just want to say, in case you don't get your question answered, you can still afterwards also email Lucinda. She's lsteenkamp@cipc.co.za. Okay, next, I see there's now a few hands. Deirdre, if you can unmute yourself and ask your question, please.
Thank you very much. If a company reclassifies its shares by passing a special resolution to amend its MOI, but the special resolution has not been lodged with CIPC, what is the effective date of the reclassification then?
There we go. When you reclassify your class of shares with a special resolution that was passed, that effective date is based on the special resolution that was passed. Remember, the special resolution is not validated by registration with the CIPC. It becomes valid on the date that it is passed, as long as it's passed in accordance with the Companies Act requirements. So your effective date will be the date on which all the shareholders approve the decision.
Does that also apply to unclassified shares then?
Correct.
Okay. Thank you very much.
Okay. Pleasure.
Okay, the next person is Denise. You're welcome to ask your question. Just unmute yourself.
Hi, I just wanted to ask you, you've mentioned ring fencing. Can you just explain that to me? I'm not familiar with that.
Okay, Denise, on the presentation, there's a short example of ring fencing, but I'll explain quickly. Ring fencing is any additional restriction that a company in itself places on that company that is not catered for in the Companies Act or that company's MOI. So, for example, if a company decides that its directors may contract with a third party only up to the amount of 300,000. That's an additional restriction that this company places on its contract requirements with third parties, on the directors. So if you as a third party don't go through a company's MI before you contract with them and see that they have ring fencing conditions and look at what those ring fencing conditions are, it may invalidate your whole contract if you act outside of those ring fencing conditions. That's why it indicates the RF next to the name of the company, so then you know that there's additional restrictive conditions attached to this specific company that you need to go and look at.
Okay, the next person is Matlowa. You're welcome. You can ask your question, please. You must just unmute yourself first. Matlowa, you can ask your question. But you muted, you must unmute.
Type this question, let me answer him.
Okay, we see your question. Lucinda will answer it. Lucinda is answering on the chat. Is there anybody else who have a question? Because at the moment there's only one person's hand raised. And the next person is Mabi Nang. You're welcome to ask your question.
Okay, thank you, ma'am. I'm on the CIPC website now, and I'm trying to find IP services, but I cannot find an option like that.
Okay, Mojale, if I can just explain to you where the IP services are on the website, please.
Thank you.
I'm not on the website anymore, but if you look at the homepage of our website, if you look at the top, you would see business registration. There is companies. Anywhere where you see IP, then you can enter and it will take you to IP services.
Yeah, if I can add to that, on the website, you will see at the bottom, there's, I think, 4 pictures usually. And the first one. The first picture is about registering your business, then doing changes to the business. And then after that, I think is the IP section. There might even be 2 columns for it. I can't remember whether it's 1 or 2. If I can just ask. Sorry, myself. Yes, I'm listening.
It's Offense here.
Yes, Offense.
Just to the
Please,
lady was.
You're welcome. You can tell us the information you have.
Just for the lady was asking where to access the IPE services site. If they're on the CIPC homepage, at the top there's a link that says online transacting. Once they put their mouse over the online transacting, a drop-down menu will appear, and IPE services is one of the options they can click on there, which will automatically direct them to the IP online platform. Thank you.
Thank you, Finse. Okay, Mapinang, are you answered or did you still want to ask a question? Your hand's still raised.
Oh, no, I'm sorted. Thank you. I'll just look for the online transacting option.
Oh, okay, fine.
Thank
then,
you.
Pleasure. Matlowa, you can ask your question. Your hand is raised again. You must just unmute yourself. We can't hear you.
How are you?
I don't know.
Can
this
you hear
is
me? Hello?
Yes, please.
Yes, it's
ask your question. Yes, please ask
thank
your
you
question.
very much for this. Yeah, thank you very much once more for this opportunity that you gave to us. indeed, it is very, 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 very making a difference in terms of the CIPC. Now, I've got a few questions, although it's not going to end today. But the only thing that I need about the issue of shares, in terms of where it was never operated before, and at a later stage, it started to operate. How does the shares going to be sold on that situation? The other question. If the company never and at stage you realize that you find some people that you're gonna make business with, in terms of that situation when it comes to the issue of
Okay, Matlowa, your sound keeps cutting out. We can't hear your question. I think the best will be if you send either a question on the chat or an email to Lucinda afterwards, because we really can't make out anything you're asking. So please ask your question on the chat or send an email afterwards. I want to give Jeremiah. Oh, okay, Jeremiah, can you please ask your question? You must just unmute. You muted. Okay, Jeremiah seems to have lowered his hand.
It's the same guy. It's the same person.
Oh, it's the same person. Okay, but anyhow, we only have about 2 minutes left. So if you have any other questions you want to ask? At the moment, there's no hands raised. So I want to ask, if you have a question, you can send it to alsteenkamp@CIPC. And in case you have other questions, you can always send it to our education unit. We will forward it to any IP questions we'll forward to Majalefa, but you can send it to education@cipc.co.za. If there's no other questions, I want to thank all of you for participating. We're very glad that we get quite a bit of interest in our webinars, and we really hope this has been valuable to you. We want to wish you a very good day, and we hope to have you join us again for more webinars. I want to thank Lucinda as well and Majalefa for their presentations. Thank you very much. And I think with that, I'm going to close. Yes, and perhaps just remember the survey. We will email you the link. You copy it, you paste it in the address line on your search engine, and you will get to the website, and you complete it and submit it. Will come directly to us. Your feedback is very valuable to us. Thank you again, and have a good day. Bye-bye.
Thank you, Elma. Well done.
Thank you.
Thank you.
Thank you.
Let's see how many thank yous. Thank you. Ndalabo.
Yes.